Vajpayee, Chairperson, and Abha Singh, Co-Chairperson, for their outstanding leadership and commitment. I also acknowledge our advisors, Mrs. Irma Chinoy, Ms. Indira Kotak, and Ms. Leena Vaidya, our former presidents, for their guidance and unwavering support. A sincere thank you to our committee members, Dr. Bhavna Trivedi, Kavita Chandran, Meena Doshi, Nikita Vardhan, Nishiti Bhavnani, Payal Kotari, Puneet Bhasin, Renu Parekh, and Tahira Manviwala, whose active involvement, teamwork, and dedication have made this event possible. As we commence this evening discussion, let us remember that laws do not merely regulate society. They reflect in values, aspirations, and vision for the future. In this spirit, IMC Ladies Wing has taken a significant step by drafting a white paper titled Prenuptial Agreements in India, a framework for recognition, regulation, and enforcement in the background of the emerging legal landscape of the uniforms. Prepared with the expertise of our legal committee and eminent senior advocate, Ms. Mrinalini Deshmukh, the white paper seeks to initiate a meaningful dialogue on the need for a legal framework governing prenuptial agreements in India. For generations, marriage has been built on trust, commitment, and shared responsibility. Yet, like every enduring institution, it must evolve to meet changing realities. More importantly, modern prenuptial laws are not merely about protecting wealth. They are about protecting people, especially children, whose welfare, education, and financial security must remain paramount in the event of a marital breakdown. The objective is not to weaken the institution of marriage, but to strengthen it through transparency, certainty, and fairness. As we prepare for the challenges of the next generation, marriage as an institution must continue to evolve while preserving its core values. This initiative reflects my theme, Evolve to Excel. Strong institutions endure because they evolve. It was my vision for the IMC Ladies Wing to initiate a constructive dialogue on the recognition and regulation of prenuptial agreements in India. We believe that a carefully crafted legal framework can strengthen the institution of marriage by promoting transparency, fairness, and protection for families. It is our hope that this initiative will encourage constructive debate, thoughtful reflection, and progressive legal reform for the benefits of future generations. I wish you all an engaging and enlightening and memorable session. Thank you.
Thank you, Mrs. Rao, for your inspiring address and sharing with us some of the important points of the bill. Now, our first distinguished speaker needs little introduction. A jurist of exceptional stature, he has contributed immensely to constitutional jurisprudence and the strengthening of democratic institutions in our country. To introduce Honorable Justice Jasti Chelameswar, a former judge of Supreme Court of India, I invite Snehalata Paranjpe, Chairperson, Legal Committee, to come on stage.
Ladies and gentlemen, it's my privilege to introduce Justice Jasti Chelameswar, former judge of the Supreme Court of India and one of India's most distinguished jurists. Justice Chelameswar was a judge of Andhra Pradesh High Court, Chief Justice of Guwahati High Court, Chief Justice of Kerala High Court, and a judge of the Supreme Court from 2011 to 2018, when he retired as the second senior-most judge of the Supreme Court of India. His judicial career is testimony to his commitment to the cause of justice. His illustrious and inspiring judicial journey is adorned with landmark decisions. To name a few, the historic Constitution Bench judgment in Justice K.S. Puttaswamy versus Union of India, which unanimously recognized the right to privacy as a fundamental right and affirmed the values of individual dignity, autonomy, and personal choice. The Constitution Bench decision in National Judicial Appointments Commission, known as NJAC case, where his powerful dissent underscored his long-standing commitment to transparency and accountability in judicial institutions. The decision in Shreya Singhal versus Union of India, which has been hailed as the cornerstone of free expression in India and a key lever in tempering prosecutorial excesses in policing online speech. The judgment in Shalu Ojha versus Prashant Ojha, criticizing procedural delays in getting relief under the Protection of Women from Domestic Violence Act. Whether dealing with constitutional governance, civil liberties, judicial reform, or the rights of its citizens, his judgments have reflected a deep concern for both institutional integrity and individual freedom. As we gather to discuss today prenuptial agreements, marital autonomy, and the evolving nature of family relationships in India in the background of the Uniform Civil Code, we are particularly fortunate to hear from a jurist whose judicial philosophy has consistently emphasized informed choice, personal liberty, fairness, and constitutional values. Ladies and gentlemen, please join us in extending a very warm welcome to Justice Jasti Chelameswar and felicitating him.
Our next speaker is one of India's most recognized public figures, admired for her leadership, conviction, and impactful contribution to public life. To introduce Mrs. Smriti Irani, I once again invite Sunetra Paranjpi.
Thank you, Amma. Ladies and gentlemen, our next esteemed guest is a highly acclaimed politician and media icon. Smriti Irani is a prominent politician and a former TV star. By former, I think she is version 2.0 also now. She left a lucrative career to join politics over 2 decades ago and has been a cabinet minister from 2014 to 2024, a 3-time member of parliament, and has held various posts in BJP. She created history in 2019, as we all know, by defeating the then President of Congress from Amethi, a seat as nearly impossible to win by a non-Congress politician. Mrs. Irani earlier represented Gujarat in the upper house, Rajya Sabha, from 2011 to 2017 and was re-elected from Gujarat in 2017. Her past ministerial portfolios include Ministry of Women and Child Development, 2019 to 2024, Ministry of Minority Affairs, 2022 to 2024, the first non-Muslim to hold the position, Ministry of Human Resource Development, 2014 to 2016, Ministry of Information and Broadcasting, 2017-18, and Ministry of Textiles, 2016 to 2021. She was India's youngest cabinet minister in the Modi 1.0 and 2.0 governments, and the first woman to hold office as Union Minister for HRD and Textiles. As the Human Resource Development Minister, She expanded initiatives promoting higher education and research. She encouraged international academic collaboration through the scheme called GYAN. She has played a pivotal role in advancing education and opportunities for young women across India. Speaking on the historic achievement of 10,107 girls qualifying for admission to the IITs in India, she remarked that this is not merely the story of an examination, but one of aspirations nurtured, barriers lowered, and possibilities expanded. She has served in the BJP in various posts such as National Vice President, National President of Women's Wing, Vice President of Maharashtra Youth Wing, National Secretary twice, 5-term member of National Executive, Maharashtra State Secretary, and she has significantly and successfully pursued Permanent Commission for Women in the Indian Army. She has also launched Saksham, the first ever vision document released by any political organization in India to uplift the differently abled in India. Besides being an active social and political activist, she has had a successful career as a media professional for over 2 decades, starting from 1994. She has worked across different fields of media, right from creating content for news and entertainment television networks, to acting in over 22 television series, 2 films, and 5 theatre projects in 4 Indian languages. Apart from her contributions as an actor, her work in television networks ranged from direction, script writing, to production. She has also contributed as a columnist to 2 national dailies. I cannot help but remember Tulsi Virani 2.0 on the controversy of 10 lakhs being spent by her and her husband pulling her up for that, when she retorts in a very spirited manner, "Ghar tumhara, bacche tumhare, ghar hamara, bacche hamare, paise tumhare." What kind of justice is this? So she has been advocating women's rights, both in her roles off screen and on screen. Please join me in welcoming Mrs. Smriti Irani and felicitating her.
Our next speaker brings with him extensive appearance and governance. You must be thinking he's a film actor, but he's not. He's an IPS officer. Public administration and policy implementation. लेकिन ब्रिजेश जी, आपको before Advocate Puneet Bhasil introduces you, स्मृति जी, एक कविता गया से एक लॉ इंटर्न आई हुई है मेरे पास, और उसने कहा कि आपकी आज ये इवेंट है, तो उसने कविता लिखी आपके लिए, छोटी सी, 1 मिनट लूंगी मैं आपके लिए पढ़ूंगी. एंड दिस इज दिस लॉ इंटर्न फ्रॉम गया. संघर्ष से शिखर तक. वह चुप थी तो लोगों ने कहा कमजोर है. वह बोली तो बोले यह तो शोर है. वह झुकी तो कहा देखो हार गई. वह उठी तो कहा यह तो अहंकार है. पर वह चली बिना रुके, बिना थमे, बिना डरे, क्योंकि उसे मंजिल नहीं अपना वजूद करना था. कभी पर्दे पर कहानी बनी, कभी संसद में आवाज बनी. कभी पर्दे पर कहानी बनी, कभी संसद में आवाज बनी. उसने हर रूप में खुद को नहीं, सोच को बदलने की आग जलाई. ये नारी है, यह सिर्फ आंचल नहीं, अंगार भी है. यह केवल ममता नहीं, प्रहार भी है. जो रोकेगा राह जलकर राख होंगे, जो साथ चलेंगे इतिहास होंगे. जो रोकेगा राह जलकर राख होगे, जो साथ चलेंगे इतिहास होंगे। यह वही शक्ति है जो हालातों से नहीं डरती बल्कि हालातों को बदल देती है। So that is, I would like a girl who is sitting there in the audience. उसने आज आपके लिए कविता लिखी। So now I request Advocate Puneet Bhasi, Member Legal Committee, to come on stage and introduce this dashing IPS officer.
Good evening, everyone. It's an honor and privilege to introduce Mr. Brijesh Singh, the Principal Secretary to the Chief Minister of Maharashtra, a distinguished leader in policing and governance. He has been instrumental in transforming the state's security and law enforcement landscape through innovation and technology-driven reforms. Mr. Singh has led landmark initiatives such as Maharashtra Cyber, Serve Maharashtra, predictive policing frameworks. Under his leadership, Maharashtra has pioneered district cyber labs, specialized cyber police stations, setting national benchmarks in combating cybercrime. He has also implemented the first automated multimodal biometric identification system initiative in India where iris, facial recognition, finger and palm prints will be used to identify crimes in Maharashtra. As Inspector General, I'll pause, you can clap for him please. You're all safe because of him. He's one of our Maharashtra stock cops. So one of the reasons that you sleep well at night, your money, everybody's money is not stolen in cybercrimes. We have cyber police stations, and now tracing and identification of criminals through biometrics is only full credit to Mr. Brijesh Singh. As Inspector General of the CID, he implemented the prestigious crime and criminal tracking system for Maharashtra Police, connecting 1,100 police stations by an advanced technology platform. Police stations which were completely isolated now work in tandem with each other. That's a great initiative which has only happened in Maharashtra under his leadership. An award-winning officer and author of The Dangerous Minds of India, a book you should definitely read. As a matter of fact, if you get a chance to get it autographed from him, it would be great. It's an amazing book to read. Mr. Singh exemplifies visionary leadership combining technological foresight with a deep commitment to public service. He often emphasizes on the importance of collaborative leadership approach, noting that effective governance comes from bringing together technology, teamwork, trust, to stay ahead of evolving challenges. That's exactly how Maharashtra is crime safe. We have cops like him who are one step ahead, and all credit goes to him for that. It's a privilege to have such an accomplished leader with us today, and we look forward from benefiting to his invaluable insights. He's someone whose work I deeply admire. He may not know that. I've never told him that directly, but yes, I deeply admire his work and the way he silently works, making Maharashtra and the entire society a much better place for all of us to live in. Please join me in warmly welcoming Mr. Brijesh Singh here. And I would want the committee members to please come in and felicitate Mr. Brijesh. Now, the lovely lady in black over here, everybody has seen 0 Hour on television. So, we have with us Ms. Sarita Kaushik, a distinguished Indian journalist and executive editor of ABP Majha. With over 25 years of experience across print, television, and digital media, she's widely respected for her integrity in reporting and her leadership in the field of journalism. She holds the distinction of being the first woman to serve as the editor of a Marathi news channel, known for her extensive on-ground reporting, including very courageous coverage from Naxal-affected regions, areas where women really don't venture. She has actually done on-ground reporting in those kind of regions. demonstrating her commitment to factual on-ground storytelling even in challenging environments. She has contributed significantly to television journalism through her very popular program 0R, and she is an accomplished author too. A recipient of numerous prestigious awards, Ms. Kaushik continues to set benchmarks in editorial excellence. She has often emphasized that responsible journalism lies in telling people what they need to know, not just what they want to hear. Something very, very important, something that she really carries forth in her journalism. Reflecting her commitment to truth and public interest. We really appreciate and admire your work, Sarita ji, and a warm welcome to Ms. Sarita over here on this platform. And requesting the members of the legal committee to please felicitate her.
So now with the formalities of welcome over, introductions, there's one committee photograph of all the members, and then I will hand over the mic to our moderator so that you can hear the speakers, ask them questions, have the panel discussion. So one quick photograph of all the committee members with the honorable guests. Please come. Smriti ji has a flight, so we are really going to run through. Thank you so much. So now I hand over the mic to Sarita ji. And Sarita ji, अब आपका काम शुरू होता है. There's a panel discussion, but before that we have speeches. We would like to hear the speakers individually. So Sarita ji, over to you. Thank you so much. Thank you for being such a wonderful audience. Thank you.
Thank you, Abaji. Ladies and gentlemen, a very good evening to you all. I need not really tell you that marriage in India is of profound importance. Because most of us after all, decide to get married, and only few of us choose to be happy. With jest apart, marriage in India spans multiple spiritual, cultural, societal dimensions. Marriage may be sacred for us, but it has also proved itself to be an evolving institution. Marriage may be a bedrock for community ties, yet it faces challenges of its own. The challenges today in modern, aspirational, global-facing, growth-centric India are also multifaceted and complex. Marriages face financial challenges, marriages face professional challenges, and marriages have digital realities to contend with. Today's discussion with such a distinguished panel aims at addressing the recognition, regulation and enforcement of prenup agreements so that our legal framework evolves to protect both individual rights and familial harmony. We are all aware that there is a line of thought which believes that prenups may promote divorces, but will not well-regulated prenup agreements enforce transparency? Will they not protect vulnerable spouses? Will they reduce bitter court backlogs and ensure that the future of our children is financially secured from the day of their birth? And this is what we would like to know from you, our esteemed panel. India is poised for a uniform civil code, with a few states having already taken the plunge. The Uniform Civil Code, as most of us are aware, is basically a common set of personal laws for citizens, irrespective of their religion. So the UCC seeks to regulate marriage and divorce, inheritance and succession, adoption and maintenance, and it is in this context that we open the floor to the panel discussion. I'm sure we would first like to hear the basic thoughts on the topic from our distinguished guests, and Sir Justice Chelameswar, I request you to enlighten us.
Sabhaya Namaha. This institution of marriage is something which is prevalent in the history of mankind across the world for millennia. Now, depending upon the place, time, and the religious orientation of a particular society, the institution of marriage acquired certain attributes, but none of these attributes remains stagnant for all the time. I don't want to give a long lecture about the institution of marriage and what all the changes. We take the history of mankind for the last about 100 years. First of all, when I talk about the institution of marriage in this country, we must remember that we have people following different religious paths in this country, a considerable number of people of different religions. And each one of these religions have their own prescriptions or perceptions about the institution of marriage. Though there is some common denominator in all these things. Now, for example, in Muslim law, marriage was always considered to be a contract. In Hindu law, it is considered a sacrament, it is not considered as contract. But even now, rhetorically, courts and lawyers say it's a sacrament. Though, in my opinion, it underwent a lot of changes. The concept of divorce itself was not known until the mid-20th century for Hindus. Though certain segments of the society, particularly the less privileged segments of the society, conventional customary divorces did exist, but not otherwise. Now, when the Hindu Marriage Act, the whole Hindu law, the law relating to Hindu marriages, succession, adoption, so on and so forth, were sought to be introduced in the 50s. A considerable opposition was there for the changes. There were elements who opposed these things. Anyway, it's all history now. But thereafter, once the law is codified, certain principles are laid down by the Parliament. There is no difficulty about it. The question is about, today the whole topic of the discussion is about the prenuptial agreements. In fact, other jurisdictions talk about post-nuptial agreements also. Let's not go into it. Our concern for the evening is prenuptial agreements. When Ms. Rajarashmi was talking to me to invite me, he sent me certain questions. How would the legal system look at this arrangement? Would it be considered inconsistent with the public policy of this country? I personally believe that there is nothing inconsistent with the public policy of this country to have a prenuptial agreement. I may tell you, even England, with apologies to the lady here, though there is a lot of talk for quite some time in this country about getting rid of the colonial past, the fact remains most of this legal system we have inherited from the erstwhile colonial rulers. Even in that country, the institution of marriage was considered a very sacred institution there also, notwithstanding certain other practices which we didn't practice those days. Divorce was a very, not very unusual in those countries. But even in England, this question lingered for quite some time, from the late 19th century, whether prenuptial agreements would be consistent with the public policy of England. And finally, from time to time, the jurisprudence evolved. In 2010, the Supreme Court of the United Kingdom, by judgment of 6-1, declared after surveying the whole legal position in this regard, there is nothing inconsistent with the public policy of England. And that being the situation, I would find it difficult to believe that a prenuptial agreement would be inconsistent with the public policy of this country. At least it's my personal opinion. Today, well, it has no more sanctity than maybe 8 years back it had a little more value. But today it all depends on how the lawmakers would look at it and how the society looks at it. That's a different matter. That's my personal opinion. And a lot of these, once, as it is said, apparently there are only two parties to the marriage, a man and a woman. Even that is not right today, after the recent judgments of the Supreme Court. The two parties to a marriage, and largely between a man and a woman, sometimes otherwise, which is legal today, declared legal by the Supreme Court. And all these things point to the evolution of the jurisprudence. What perhaps was not accepted from 20 years ago, now it becomes a legally acceptable thing. In which case to say that a prenuptial agreement is not consistent with the public policy of the country would be a very strange argument. Now, what are all the areas where a prenuptial agreement can be entered into? Well, these are matters of detail, and a draft bill is placed before us, which broadly covers various aspects. And I may tell you, for the benefit of the non-lawyer friends sitting in this gathering, in quite a few jurisdictions in Europe, prenuptial agreements are enforceable. Though in England they are not strictly enforceable, but the courts take a very significant notice of a prenuptial agreement. They don't deny it altogether. In certain other jurisdictions in Europe, they are legally enforceable agreements. Now, are we, with all the developments in the law and the recent pronouncements of the Supreme Court, dealing especially same-sex marriages, judgment dealing with live-in relationship, the judgment dealing with the transgenders' rights and so on. To believe today that such an agreement would be inconsistent with the public policy, at least I find it very, very difficult to accept it. I think with these introductory remarks, I request the other members of the panel to...
Smriti ji, your thoughts. Thank you, sir.
I think if we take off from where the good judge spoke expansively on what is happening in the UK, I would like to reflect on empirical evidence which has come on this issue between the UK and the US. In the UK currently, the average age of marriage for a woman is 34, and the average age of divorce for a woman is 44. As compared to the average age of women getting married in India, that is around 22.9 years. Now, if you look at empirical evidence that has emerged both from the UK and the US, how are not only prenuptial agreements but marriages per se looked upon? There was a study done by the Harvard Law School in the year 2003 as to what is the sociological, psychological impact of prenuptial agreements on marriages and how they are perceived. Of the people that were polled for that study, close to 63% said that the minute you say the word prenup, that is a pronouncement that your marriage is doomed to begin with. But what was interesting is that of the general population that was polled, there was a separate poll for law students. And these are law students who are supposed to just opine on the legality of the concept. 56% of law students said that the minute you say you want a prenup, your marriage is doomed to begin with. If you look at the UK today, as I said, the average age of divorce and marriage tells you that the average marriage lasts 12 years. And prenups have gone up by 20% now. The indicative comparison is that as compared to, let's say, 2 decades ago, prenups have gone up by 60%, but still are at 20%. And one of the reasons why prenups have gone up societally, collectively, only up to 20% is that people are getting married later in the UK. They are accumulating, assimilating wealth. They want to make sure that their assets are protected, and if they have offsprings from other relationships or marriages, those offsprings and their economic rights are protected. Similarly, in the US, there was a widespread research done between the economic impact, societal impact, and psychological impact of a marriage breaking down. Any and every conversation around the concept and institution of marriage, when you look at it from a European influence or an American influence, is always based on the premise that a contract will help dissolve a marriage peacefully as compared to the absence of a contract. Now, what has happened in the US, they studied what happens when a marriage breaks down. Is the impact on the two people in the marriage, or the offspring, or does society and the nation also pay a cost? You would be shocked that of all the studies done, the impact on a child of divorced parents is that their earnings as adults go down by 9%. Apart from having impact psychologically, depression, anxiety. But research in the US also researched the economic impact on the taxpayer. And they concluded that the economic impact per year out of divorces and unwed childbearing was $112 billion per year and $1 trillion for a decade. Now, that being said, I will not get into the premise of whether a prenuptial agreement is to be looked upon from the prism of the Contract Act or whether it should be assimilated in the UCC. That is an opinion for Parliament to give. But as somebody who is a practicing Hindu, when we say it is a promise of union of two souls in front of the divine, it is pragmatic to look upon issues like divorce as an instrument of separation which will have a judicial intervention. It is pragmatic to look at
ensuring that more and more women know about the concept of Vidhan and how to ascertain their economic rights under that framework. But again, like I said, whether such a construct is to be flagged under the Contract Act or under the UCC, that is for the Parliament to opine on. But a larger construct is this. In the US, in the UK, ultimately, even in the state of Goa, I asked, who or what kind of people are the ones who are getting the contracts done? Overseas, it's all of those who have predominant generational wealth or who have accumulated mass amounts of wealth. It is one of the rarest forms of engagement for a middle-class couple and never to be seen amongst the poor or the lower middle class. So there is an economic disparity to the construct in itself, which I think becomes a part of larger public discourse. So there is a need to separate the legal conversation around it and a societal conversation around it. Thank you, Smriti. Brijesh.
So I'll speak like a policeman. And primary thoughts on it, it's complicated, right? So in the good old days of Facebook, when a couple was going through marital discord, they would change their status to it's complicated. And trust me, as a policeman, we would like to be assigned to a robbery case, murder case, cybercrime case, not to a domestic dispute. It's very complicated. Now, going into the history of it, if you look at, if there was one provision in the Constitution which was the most secular, probably it's the UCC. And if you look at the Constituent Assembly debates, you'll find that it was there till the last moment as a fundamental right. And only in the last meeting, because of objections of a particular committee, it became relegated to a directive principle of state policy. Now, if we go into the roots of secularism, it also starts from a domestic dispute. In 1527, Henry VIII wanted to get divorced from Catherine of Aragon. And the Pope VII, who was in Rome, said, "No, you can't do it." So this guy then created this concept of separation of the church and the state, from where the roots of secularism began. But you know, ironically, this was created to protect the state from the church, not to give religion a special right as it is being construed in secularism, about secularism in the modern debate. However, see, if you look at the experiments around this directive principle of state policy being made a law in Uttarakhand or in Goa. Goa was basically the Portuguese law which we took over. But in Uttarakhand or at various other places where there are drafts, I think a prenup without a UCC is, in my view, not possible today. Because when you want to challenge a prenup in the court of law, that that argument of it should not be against any public policy of Section 23 of the Contract Act comes into play. And it is upon the judicial mind of the person who is sitting there to adjudicate. But if you look at the major judgments, 1891, and then, there are three major judgments which are kind of years apart, where basically a prenuptial arrangement was held to be void because it was against something. Maybe let's say personal law or something else, or probably conjugal rights or things like that. Now, in this scenario, if you really want to have a prenuptial agreement, I think it is not possible without a uniform civil code. Uniform civil code, also when you can have a uniform criminal code, why shouldn't you have a uniform civil code? If something is not in consonance with principles of humanity, equality, basic human sensibility, like age of consent of marriage, Now these things have to be codified it's the duty of the state, it's the duty of the state to protect all the citizens appropriately. And I believe that prenuptial agreements are very good, but in the present state of law, it becomes difficult. It's actually increasing. If you do it, it would increase the caseload. But while implementing this, we have to be careful because the devil lies in the detail. Because prenuptial agreements or arrangements may be dominated by the side which is more powerful, or in any way, it may be socially more powerful, they may have more power in the relationship and things like that. And that is why there have to be some kind of safeguards. There has to be, some kind of cooling period. There has to be counseling. There has to be an understanding of what rights are being relegated. And without a UCC, something major which happens in the West is that people give away the right to alimony. That is not possible under Section 28 of the Contract Law, because you cannot give away your rights even with an agreement. So I believe that this is essential, but not possible without a UCC.
With your permission, Sarita, I just add to what Brijesh has just said about the power dynamics of those who want to enter into a prenuptial agreement. And you'll be shocked that there was research on this as well. 67% of prenups were in the length of 14 days before marriage. And 33% happened 4 days before the marriage. And that is because of the power dynamics. One party was economically more powerful than the other. And the research concluded that the one party that was not economically as imposing in the relationship signed it off in the hope of romantic optimism.
I think we should have hoped that it was the other way around, but it doesn't seem to have happened. Sir, I come to you with my first question. As you...
Aspect of the matter, as the draft will, I went through it. The proposal is that both the parties should have legal advice before entering into the prenuptial agreements. Now, it's good that somebody should have, before entering into a contract, they should have competent legal advice is a good proposition. But then, having regard to the Indian reality, this option, is it available to how many people? What is the percentage of people who have this option of availing legal advice? And without making any disrespect to the legal profession, in a country of 140 crores of people roughly, and then about 500,000 lawyers, I think, approximately, latest information I have not obtained. How many people will be able to obtain this legal advice before entering into a contract is a serious question. Unless state comes forward with some kind of a legal service in this regard. And having regard to the economic realities of the Indian society, this bill, if at all it gets the approval of the Parliament, perhaps to start with, long run what happens, of course, when I talk about long run, I'm always reminded of a famous statement of Maynard Keynes, in the long run we are all dead. I'm not talking about that. The immediate benefit would be to a very limited number of the people in this society. Now, that does not mean it should not be undertaken. The beginning. But this is an aspect which should be considered when you're talking about a prenuptial agreement on the basis of legal advice to both the parties, apart from various other requirements, the contract, is something which requires a serious consideration.
Yes, sir. I believe that is where we are speaking about regulated prenup agreements. Unregulated, yes, maybe that is what... When we speak about unregulated prenup agreements, probably they would function as loose cannons, as you say. They could go anywhere. But today, the whole idea of this discussion is to see how prenups can be regulated into the framework of law. And probably that will do away with the pitfalls as you...
All this requires a large-scale debate.
Yes.
And involvement of stakeholders. When you talk about stakeholders in the context of this kind of a thing, the whole society. Well, how many members of the society would participate in this kind of a debate is a question. Yeah, it is debatable.
Yes, but it has probably to happen. One thing, sir, that you did tell us was that you find nothing inconsistent in public policy to prenup. So, taking it forward, I would like to ask your opinion. If UCC is enacted, then should prenup agreements be given statutory recognition within the UCC, or should it be left to the contract law?
I don't think it makes any difference whether it should be part of UCC or independent. It is a law made by the Parliament in whatever form it comes.
But then you feel that in the present form, the Indian contract law is capable of protecting prenups?
I believe so personally.
You think there is no need for a separate provision in the UCC for it?
Need is a different matter. See, my personal opinion need not necessarily be the opinion of all my brethren sitting in the courts all over the country today. They may have different opinions about different things. But once a statute, it obtains a statutory recognition, then the courts are bound by the statute. So therefore, it is always better to have it enwrapped in the statutory thing, whether it's the Uniform Civil Code or some other law, whatever name you call it, that's a different matter. It's always better.
My next question is, Smriti ji, for you. You did elaborate on the US and the UK, but you have yourself been involved in the women empowerment policy of the country, and you have seen women very closely, their issues very closely. How do you see prenup in the context of Indian women?
I think I'll take a page from Brijesh Singh's experience as an administrator. I had the great privilege of helping set up, as per the Prime Minister's direction, the one-stop centers across the country in every district. Also, one of the, I think, very successful attempts in collaboration with the judiciary was the setting up of 1,064 fast-track courts, which helped adjudicate, till my last count when I was in office, close to 175,000 cases with alacrity. Under the one-stop centers, we basically provided free service, legal aid, medical aid, police support, and short stay home to women who were either getting out of very violent marriages or were victims of sexual or violent attacks and assault. Those were close to 3.5 lakh cases. And as Brijesh said, that one of the biggest challenges for police on ground is that immediately after the assault or immediately after the breakdown of the marriage, the emotive strength of the woman is so high that she would want to file a case. However, when the officer and the lawyer revisit, then the lady would want to either defer the issue or withdraw from the issue. And that is where the case load and the administrative burden on officers on ground becomes a challenge for those who are trying to administer and implement the law. And across these over 5 lakh cases that I've had the responsibility of reflecting on, none of them had a semblance of a prenup in a marriage. Because all these women entered into marriage never with the presumption that it would break.
So you feel that if they did have a prenup, it would have been better?
No, I think that there is a reality we need to contend with. Prenups is not a reality for middle class, lower middle class, poor women. It is, and I can bet for the lack of a better word, given that you said I'm reflecting on US research, I can bet $1 on it. That if you look at all prenups, 99% of them emanate, in fact, again, I'm going back to research, of all the prenups that were studied in the US, they saw that those who wanted to get the prenup done was the extended family of those people who had generational wealth. So this was not even an individual decision. Research shows that it was the extended family that wanted the wealth, the companies, the shares, the estate to be protected. So that is why, to simplify it just to a document or a conversation is not to recognize the complexity of the diversity we enjoy as Indians. We are a country that speaks 19,000 dialects, 125 constitutionally recognized language.
Smriti,
and a prenuptial agreement, if you go even to, let's say, a small family of 4 in Kandivali, it is not a consideration when they are looking to marry someone. That is the reality that we live in. So when Parliament opines on such issues, Parliament, I do not presume the position of it, and I am mindful of the fact that it's my government at the centre, but I am sure that, as the good judge said, it is not only a legal conversation, it is genuinely a societal conversation.
I think nobody here will differ with you on what you said. But having said that, and completely agreeing with you that it is not an issue at all with the middle class of the country, having said that, the very trauma, the very ethos of the women which you laid bare before us just now, do you not feel that a prenup would have empowered them?
So there have been prenups, and again I'm deferring back to Brijesh. There have been prenups where spousal economic maintenance for the offspring of the marriage in the prenup are already signed off as denied. Courts have intervened and overturned such contracts because the female component of that contract was not as economically powerful as the man. And that is why, for you to presume that the prenup is going to be an assurance for the female to be financially, legally protected is again to suffer from a myopia. Because reality is that courts have intervened to overturn such contracts which were totally one-sided. And that is why perhaps your legal committee has said that women need to be legally guided, or both the individuals have to be legally guided before they enter into such a contract. So between the 3 panelists, I am somebody with a policy and legislative experience. Of course, Justice has had years of judicial leadership, but you have to factor in Brijesh Singh's experience, because that is the reality that we live in.
I'm going to come to that question also later, but I am again going back to you because it is.
If you ask me for my personal opinion, I have actually given up my succession and inheritance rights because I'm financially more successful than my siblings. Listen, I don't have generational wealth. I'm a self-made person. But if you ask for my individual opinion, if I don't have the man, I don't want his money.
Legally, but maybe a little.
I think this is a good sentence to clap at.
Sarita was basically egging me to give my personal opinion. That is why. But as a politician, my opinion does not count. As a politician, my responsibility is to reflect on the needs of society and to ensure that there is a healthy, robust, comprehensive debate, and let every segment of society not only speak for it, let Parliament debate on it, and Parliament is robust enough to consider international law, to reflect on international experience. So give Parliament the credit when it's due. They do not suffer from blinkers on and taking an issue at hand without seeing the comprehensive judicial, societal, economic impact and administrative impact of every issue before them.
The Parliament, as we see it, represents the people of the country. So it is their needs, their ethos, as we need have to be reflected by the parliament, and only that will make the parliament robust. I appreciate your individual opinion, but in our society, when women enter a marriage, many of them are entering with very little financial literacy.
So I entered a marriage with genuinely $200 in my pocket.
But
that is not the issue. The issue is
these are two different things.
That's what I'm saying.
Less money and less literacy are two different things.
No. I think that the issue before us is that a legal committee has looked at the whole landscape of UCC. It has seen, I'm sure, opined on the question of the Contract Act as well, and hence now has proposed a draft which says, can you look at this agreement under the aegis of the UCC? That is the question before us. What is beautiful about the panel is that you have somebody with ground administrative experience of implementing what the courts have adjudicated on. And that reality is a daily reality. It is not a reality which is a constant. And that is why I am deferring to that panelist. Because ultimately, no matter what we opine on, no matter what legislation is passed, no matter what is adjudicated, it is that last mile officer who is the flag bearer of that.
Why should the system make the people? The system should be made for the people.
Yes. So that is why, like I said, so if it is not a reality for all people, that's what I'm saying. If it's not a reality for all people, then what should be the legislative reality? Something Parliament opines on, not one segment of people.
Smriti ji, may I ask you that do you feel that women in our society often enter marriage with less financial literacy as compared to the man in the marriage?
I think that, and this is something that I have personally done under the aegis of not only my partnership with the CII but also the World Economic Forum. There is a presumption that if a woman's salary and paycheck is enhanced, then her financial powers in a family unit gets enhanced. That is not true.
I agree.
So if the premise is that if you have more money, if you have more information, hence you are comprehensively more agile about your rights, that may not be true. And it goes back also, there is a presumption again that if you create your own wealth, you will be protected against spousal abuse. There is actual research which shows that it is not essential that just because you have a paycheck, you will not be a victim of domestic violence. In fact, the only thing that shows that you are less probably going to be a victim of domestic violence is when you own capital assets. So the question before us is not only how much can women earn, but also how many women do we encourage to buy capital assets out of their earnings. If I have to go and today reach out to women, especially young women, what is the first thing I would appeal to them? That if you have savings, if you have money, the first thing you do is build a house for yourself. And that is where you will see fissures not only within a married construct, but even in your mica. When you say, I want to buy a house and I want to buy it. So we want to simplify what happens to women from the perspective of money, from the perspective of family control. And we are presuming that there is only a loss of control in a marriage. If you look at NCRB data, a lot of assaults happen from within families. So that is what I'm saying, that to have a simplistic view on the issue of women and their economic rights and their physical safety, given the amount of experience one has had on the ground, I think would be doing great injustice to my own journey. And that is why I'm not diluting it or simplifying it, because it is a complex issue. And that is why what is legislated is not the final word. The beauty of this democracy is that then it can be given for judicial review. It can be given for judicial opinion. and a comprehensive view then comes out before society.
Smriti ji, I have to.
Just a small addition.
My next question is for you.
No, just a small addition to what ma'am is saying.
Okay.
In fact, ma'am, in reality, if you look at the government data, when subsidies were to be given for Ujjwala Yojana, we found out that the cylinders were not in the women's name. And it became so difficult because you have a scheme here where you want to pass on this subsidy. So this is where policy actually created this ownership. That just to take advantage of the Ujjwala Yojana, husbands pass on the ownership of the cylinder to the woman.
So that is exactly what I was wanting to drive at.
And build homes, 4 crore homes built. And the policy intervention was, this is not a legislative initiative, the policy intervention was that either the house is completely in the name of the woman or jointly owned between the man and the woman. So 4 crore homes built for the poorest of the poor in this country, out of which 2 crores are unilaterally in the name of the poorest of the poor women in this country. And that is what I think is the intervention possibility.
Because today's topic is about prenup, probably that example works more for what I was saying. There was a time in this country when women went and did the sati. It was a statute which made it illegal, and slowly we moved away from practices like that.
Actually,
it's
historically debatable. Like
it's a British
project. It's a British project which basically, makes us feel about our history. It was not so common. If you look at the actual figures of the history, I can give you figures.
I'm not going into the statistics, Brijesh. My question is, it used to happen, it doesn't happen any longer. And it has taken us some journey into the entire process.
The way we paint our past in this way, just because of a certain colonial legacy, is something we should be very aware of. So,
I agree with you, but the fact is that there are so many examples of the same, and we have none today. So that is a reality which we are seeing. It is an evolution of our society over the years, whatever the number may be, I grant it to you. But it was not non-existent. Now, similarly, that is what I was wanting ma'am to talk about. And there are measures which empower women directly or indirectly, as you rightly told us about the Ujjwala scheme. So basically, can't prenups be that one step forward? And when I'm saying prenups, again, I'm not talking about loose cannons. I'm talking about a well-enforced, a well-regulated system. So actually, coming to the overload on the administration that you spoke about, we know that e-registration has worked. We are registering our property documents all the time now. So can it work for prenups?
Two things. Look at the Uttarakhand thing. It's totally online, right? Everything has to be registered online. See, we as India, we should be proud that we run today the world's largest digital public infrastructure. We have digital identity, digital payments, and look at just the figure of digital payments. The digital payment ecosystem in India is together more than the GDP of Mexico and Australia taken together. Right? Just the UPI payments. And in this regard, government has a very robust digital ecosystem. In fact, if you talk about Maharashtra, we have something called a golden data project, wherein that the Chief Minister says this, we have a very tech-savvy Chief Minister. He says this, that if the citizen has given you data once, or you have given the data to a citizen, you are the one who has given the license, you are the one who has given, a college completion certificate, degree, why are you asking the citizen again? It is your government database. So the government of Maharashtra has something called a golden database, which is single source of truth. Now, however, it can be digitally implemented, but there are serious concerns here where you should convince the public first that it is not some kind of an eminent domain operation, where, the state is literally getting into somebody's bedroom. So you have to demonstrate by way of how you construct technology that this is fair, this is transparent, this is reasonable, and that there is an audit trail, and that it is also just. So it is the way you construct technology also delivers justice, because technology by itself can also be very unjust. And that you're seeing, especially in terms of usage of AI, that how AI can be biased. If you give it the employment data or recruitment data of past, it will start discriminating against women. So I believe that while you use technology, we should be very careful that technology is fair, unbiased and transparent.
From an administrative point of view, how could we best integrate a prenup agreement registration into the existing marriage registration?
See, land registry has been automated, and registration today can be done very simply. So it's technologically a very, very simple thing. You can simply create a layer of contract. If you want, you can also do it on a blockchain, which is immutable. And that should be it. So I don't think so technologically there is any problem. It can be immediate, it can be transparent, it can be immutable.
But can this kind of a system ensure that the prenup, when it comes for attention, which is usually many, many years later, when the marriage suffers, so at that time, it should not suffer from inadequacies of procedure or
not at all. There are absolute technological measures. You can simply put a hash value to it, right? You put a hash value in store, and then even after 100 years, you compare the hash value, it is immutable. So technologically, there are solutions. The main point is about designing a technology which should not be like the fence is eating the farm.
I come to you, sir, again. I believe, without elaborating too much, I would like you to comment on what Smriti ji said. What is your opinion on the views that she expressed about prenup and the societal need for it, or lack of need for it, rather?
See, first of all, you are trying to introduce something which is not there, which is not tested. Now, if the experiment is to succeed, necessarily all the stakeholders should be appraised of the situation and their views count a lot. And it's not something like the criminal law. You do this and I'll send you to jail is not the situation. It depends on active agreement and participation of the people. And then marriage is something, barring very few exceptions, every human being will have to go through it. Every human being does not go to jail after committing some crime. Everybody doesn't commit a crime. Marriage is something with barring exceptions here and there, saying some people. Almost 90% of the human race goes through this ritual. Naturally, their views are, their debate is to be there.
So, sir, the whole idea of a prenup agreement is basically protecting the vulnerable spouse. So, yes. So the critics of prenup argue that it could disadvantage women who have often less bargaining power at the time of marriage. So, as opposed to this, should not the law's response be to build a protective scrutiny? Even as I'm saying it, I'm asking you, is it possible to build this protective scrutiny? How can the law address the issue? Can the courts retain the power to set aside or modify the clauses which were unconscionable at the time of the signing?
No. See, what kind of a protective mechanism are you thinking of to protect the women? Because you start with the belief that women are at a disadvantageous position. Most of the cases, yes, I agree. But then what kind of a protective mechanism can you think of? On the other hand, I was mentioning to you earlier in the 2010 UK judgment, the court took care of all these things. Whether the prenuptial agreement is binding or enforceable or not, it's a valuable input at the time of the resolution of the marriage. Now, even then, the court is required to examine, that's what the Supreme Court said, whether the prenuptial agreement was obtained, is it paid first of all, whether it was obtained with proper legal advice, whether it was obtained without any unconscionable pressure. in fact, the court drew a distinction. Unconscionable pressure. In the law of contract, there is something called juris. A contract entered into under juris is a void contract. But there is a thin line between unconscionable bargain and a contract under juris. Is there anything unconscionable about it? These are all factors which the court. Eventually, you need to go to the court. Some court, whatever the family court or Supreme Court, whatever court, that's not the point. Some independent arbiter to examine the circumstances whether the prenuptial agreement is really genuine, equitable. A adjudicated process is required. I can't speak for that. But if you're talking about a mechanism to protect before the prenuptial contract is entered into, I'm not able to imagine what kind of a mechanism, if you can kindly
educate me. I wanted you to tell us.
No, that's what I'm saying. I'm not.
How does the concept of meher in Muslim law fit in all this?
Basically, in Muslim law, marriage is always considered a contract. In fact, in that sense, Muslim law is far ahead of all of us in this concept at least.
So is that a prenup really? Is that a prenup really? Would you call that a prenup?
No, then we are going into other areas. That's not good. We are going beyond that. I am not on that.
So coming to the UCC, basically with state after state in our federal structure is implementing this law. Does it kind of do away with the basic premise of having the same law for the entire country, with every state enacting its own code?
What makes you believe that the entire country should have one law in this matter? No, ma'am, I don't know which part of the country you come from. I'm sorry for that. No, I'm serious. Actually, which part of the country do you come from?
Maharashtra.
Mm-hmm. I don't know much about this thing. Mm-hmm. In South India, from where both of us come, it's perfectly legal and morally unobjectionable, religiously approved practice for a man to marry his sister's daughter. In parts of India, especially North India, it's considered incest. So therefore, to believe that the entire country should be governed by one law is itself a dangerous proposition.
But if I were to live in one...
There are too many practices which develop over a period of millennia.
I appreciate where you're coming from, sir. But if I were to live in one state today and live in another tomorrow, then different laws would apply to me.
Ma'am, this is not such an insurmountable problem. See, you're talking about, just if I have a couple of minutes, there is a fantastic book on private international titled Conflict of Laws by authors called Daisy and Morris. The opening statement in the book is something like this. I'm not reproducing, but broadly something like this. If a Frenchman marries a German woman in Moscow and they live in New York, and eventually they fall apart and sue for divorce, what is the law applicable to them is the question. No, it's a serious question. These are all questions debated in private international law. There's a branch called Conflict of Laws. So therefore, these are not such an insurmountable. These are all these things are tested.
Sir, I'm probably thinking more of, let's say, more than 10 lakh of labor. More than 10 lakh of labor, or lakhs, I may not even know.
One normal rule here in private international is people carry their personal law wherever they go. If two Hindus marry and they go to New York or live in Moscow and finally they go for a divorce. Normal principle of international law is that the principles of their personal law, the Hindu law, would be applied by the court.
But in this scenario, in the country where we are talking about having a uniform civil code, my question pertains to that. We are talking of a country where we are to have We are moving towards the UCC.
If you think uniform civil code means...
So you feel it's untenable?
One size fits all is not uniform civil code. There are certain broad principles. Not that for every aspect of marriage, for every legal aspect of the marriage, one principle. I told you one glaring example. How do you reconcile this? Please tell me. You go and tell this somebody living in UP or some other part of the country, they say it's incest. But how are you going to say all the South Indians are resorting to incestual marriages?
Yes, so that is exactly what I'm asking you. What will happen?
It's not possible.
Because if different
that kind of uniformity, rigidity is not possible in law, in any field. A reasonable classification doctrine exists in law. So therefore, uniform...
So you mean, just simplify this for me, sir. So you mean to say that uniform civil code is not the right solution?
It all depends on what is your definition of a uniform civil code first. That everything concerned with personal laws is uniform for each citizen in this country, irrespective of his place of residence, his social background, his cultural background, his religious background, you won't apply this. Now, some things may be yes. Now, not that every aspect should be universally applicable across the spectrum.
So yes, so that is your opinion, but yes, I understand, I appreciate it, and that is what we wanted to know. Brijesh, I'm coming to you with this question. It's a very real thing. Each state is going for a law. At the same time, the country is also discussing a uniform civil code. We are aware that in some of the states, certain categories of people have been exempted from, but not all. And amongst them, like the good judge said, there are people who probably come from with different cultural roots. So how do you see the implementation? Given the pitfalls, as he points out, do you see trouble implementing?
See, if you look at any law, be it even law of physics, at boundary condition it starts breaking down. If you are going to consider certain examples which are like Six Sigma, which are like very fringe examples, see, most of the people, 99.9% people are going to live in the same jurisdiction and the law would apply to them. And then, if you're only looking at those people who probably move out of this jurisdiction and move out there, that happens. There are so many local and special laws which apply. Like Gujarat has prohibition, Maharashtra doesn't have, right? And there are jurisdiction of law would prevail. However, if you look at the Constituent Assembly debates, there were practical issues, which Honorable Justice is also talking about, regarding the implementation of UCC then. But society has changed, and if there are things which are absolutely abhorrent to basic human rights and sensibilities, I think that can be definitely tackled, and the state can give a modicum of equality, right and justice to especially women, utilizing UCC. And that's why for the whole country, rather than state by state, UCC, I mean, I'm nobody to opine on that, but it can be a solution to various social ills.
So if I were to ask your studied opinion on whether it should be UCC at a state level or a uniform approach for the entire country?
See, it doesn't matter because law would apply in case of a dispute, right? And it would be a very fringe case where you would have a cross-jurisdiction case in case of state laws. If it is across the country, it would apply equally to everybody. But see, whatever you say, there would be an initial caseload where there would be differences of interpretation, challenging the very virus of the law, so on and so forth. After this period, at least administratively, I feel that if there are sufficient provisions brought in the very architecture and the language of the law, that definitely would reduce caseload at the field level, because most of it is about some kind of a dispute regarding custody, regarding inheritance, regarding property. If this is codified earlier and assured, then this may lead to less caseload later.
Smriti ji, your opinion on it. A state level UCC or a uniform?
I think, like I've reiterated, I shall do so again. It is my party in government at the centre. the states that you speak of are also governments formed by my party. I will not presume the position of Parliament and Parliament opines on it. I am only given my legislative experience of the knowledge that when Parliament opines, as Justice Chelameswar has said, it will take into consideration a wider societal construct, debate, consult all stakeholders, and it will also see its generational impact of the law. And like I said, the fact that in a robust democracy, then we also have the capacity of the judicial review and the judiciary to opine on it is what will ensure at least that any pitfall or any challenges can be met constructively in a collaborative fashion between not only stakeholders, society at large, but also legislative and judiciary. The last mile officer is then authorized to implement this particular construct. So till such time Parliament does not opine, especially given my legislative and cabinet background, I should not proffer and presume a position of the Parliament. Yes, sir.
One more thing I may point out. The framers of the Constitution are conscious of these problems. Personal laws are therefore kept in the third list concurrently. Both Parliament and state legislatures are concurrently conferred with the jurisdiction to make laws. Because the constitution makers are aware that there is nothing uniform in this country. Even within one particular religious group, there are innumerable differences. So therefore, it all depends on local conditions. Therefore, the framers of the Constitution believe that the authority to legislate with respect to the personal laws should be concurrently given to these things. Now, if Parliament ever chooses to exercise that power to the exclusion of that it can do, still the state legislatures would have the authority to legislate subject only to the concurrence of the President of India. President of India. This is the structure.
My last question to all of you. I'm taking off again from what you said. The states better implement a UCC than a more uniform countrywide.
Come again?
You feel a state implementing a UCC is.
They're all value judgment. I don't propose any value judgments always. These are the possibilities, I said. I'm not saying the states would be better off. But the constitution makers are conscious of these problems. Therefore, they give sufficient play in the joints. That's all.
How would you deal with the reality? I mean, you are all opinion makers. So it's not about value judgment. It's about your opinion. And people here have come to hear your opinion on the topic, which is why we would like to know, as I round off, whether you favor, I have it already from you, that you don't favor the UCC as a
I'm not saying I
single code for the entire country.
I'm talking about the possible.
The problem.
Feasibility.
The feasibility, yes, yes. So it is indicative of something, sir. It is indicative of something. It is indicative of something. We have to arrive at some sort of a conclusion of where you are leading us, of where you are pointing us.
Firstly, it is Parliament that will lead us to a conclusive legislative framework and law.
Ma'am, we want the Parliament to lead us where the people want to go.
Ma'am, please allow me to finish. Firstly, to prescribe the notion, and I mean, pardon me for saying this, I don't think Justice Chelameswar said that he is against the UCC if Parliament ever so chooses to opine on it. That is not his position. I think I have heard him correctly. I don't know about the... Is that correct? Okay. Secondly, the fact that I could hear him clearly and they concur, that means as a politician, I do have the knack and the art of asking for public opinion.
There I agree.
And imagine if just being a minister for 10 years gives me that experience. Those people sitting in Parliament, men and women, have enough administrative, legislative experience to hear the voice of the people. And that is the conclusion, at least for me. That as an Indian citizen, my democracy is robust enough. I have 1.5 million women who are elected to office in panchayats in this country. And if we have the capacity as a democracy to vote for 1.5 million women, the largest political elected cohort in the world, then we know how to listen to opinion. I had the greatest privilege of writing what is called now the new education policy. And that policy was not written in the power corridors of Delhi. We went to 225,000 village education councils. So there is a constitutional framework in this country. There is a framework for discourse deliberation in the country, which is not limited to Parliament, but Parliament listens to those processes, is what my position is. And at the end of the day, if any individual citizen, organization, cohort, association, including the IMC feels that it is not being scrutinized enough, you always have the court of law. That is my conclusion.
Thank you very much for summing it up. But Smriti ji,
I just want to add one thing that I can only say, this is my wish list that this debate happens in IMC and with all these people on the stage. This is my wish list that the starting point is starting here in Mumbai and from IMC. Eventually this will go to Parliament. We are going to push the Parliament through MPs and legislative councils. That is also my wish list. And then Parliament will send it to Law Commission to look into it. And that's when Law Commission will decide how to frame it. We'll go back to Parliament and then go to President of India, as it was already mentioned. But this is my wish list. What's wrong in wishing? I'm dreaming it.
Yeah.
So I just hope it works that way.
Yes, so with this wish, I would like to invite Ms. Anita Chauhan, President-elect IMC Ladies Wing, to deliver the vote of thanks. But before that, we were thinking of having question answers, but I think the panel discussion was so interesting that I am told that there's not much time, as Smriti ji rightly says, she has a flight to take. So over to the new President-elect of Ladies Wing, Ms. Anita Chauhan.
Thank you. Good evening, ladies and gentlemen, and what a mind gym. How many of you are really going to carry this forward from multiple perspectives wherever we go back and wherever you go back? How many of you feel that it's going to really carry forward in your circles and your groups? How many of you feel that way? Wow. So we have that opinion there in that sense. As we conclude this insightful and great engaging evening with tremendous amount of food for thought, it is my privilege to extend a heartfelt vote of thanks on behalf of the IMC Ladies Wing. Today's discussion has highlighted the importance of addressing emerging legal and social realities through informed dialogue and thoughtful reform. The perspectives shared this evening have enriched our understanding of the evolving landscape of the matrimonial law and broader conversation surrounding the Uniform Civil Code. Our sincere gratitude to Honorable Justice Jasti Chelameswar, Ms. Smriti Irani and Mr. Brijesh Singh for sharing their invaluable insights, wisdom and experience. Your presence has elevated this discussion and made it truly memorable for all of us. A special thank you to our moderator, Ms. Sarita Kaushik of ABP News, for steering this conversation with grace, depth, professionalism, and courage. We are particularly proud that the IMC Ladies Wing has contributed to this national discourse, as Rajya so graciously mentioned, through the drafting of a white paper on prenuptial agreements in India, a framework for recognition, regulation and enforcement in the background of the emerging legal landscape of the UCC. My heartfelt appreciation to all the members of the legal committee whose hard work and dedication made this event possible, the ladies in the front lines. Hello. We also extend our sincere gratitude to Reliance Industry Limited for their generous support and partnership. Finally, thank you to all our members, guests, media representatives and friends of the IMC Ladies Wing for your presence and participation. Your engagement is what makes conversation like this meaningful and impactful, and also a little stretched over. As we leave this evening, we carry forward not only the ideas discussed today, but also a renewed commitment to fostering fairness, dignity, and justice in our society. Thank you very, very much, and have a wonderful evening.
Thank you, Anitaji. I think we can have a picture with the present and the coming president. So we will have. Thank you so much for this lovely evening. I think the legal committee also wants a picture, so the legal committee can come immediately. The ones who have drafted, Payal, I can spot Payal there, Taira, Kavita. You all want a picture? So the legal committee, please hurry up, we can have before Smriti ji leaves.